Hello, welcome to our weekly COVID updates. I'm going to give it a few minutes for people to join, and then we will get started. I hope you all have been having a good week. Clearly, we've got some good news on the horizon, and so I am thrilled. I know that the changing of the updates from Monday to Wednesday may have been, it's going to take some people some time to get used to, but hopefully, you know, folks will catch on to that. So let's get started with our updates. First news, great news. President Trump rescinded the restriction on F1 students taking totally online classes. That is not surprising considering just the other day, 14 other schools joined in the lawsuit. You remember Harvard and MIT first filed a lawsuit against the restrictions, and then USC joined in, and now 14 other states had joined in the lawsuit. So as a result, the president rescinded the lawsuit, but you know, it's not over yet. He did state that he's going to sign some additional executive orders that may impact immigration. So stay tuned for that. Today, we want to talk about the missing pieces to the immigration puzzle. You know, with you know, premium processing in place, what that has done is that has really increased the number of RFEs. As soon as a case is upgraded to premium, there have been RFEs that have been instituted. So today we thought, let's tackle some of the RFEs and talk about some of the other updates that may be relevant to all of you. So let's get started. We're going to talk about specialty occupation. I'm sure there's questions on first day CPT, any F1 issues, but I'm going to focus most of it on the H-1B responding to the request for evidence and try to give you some really useful tips. I mean, we're going to take a deep dive into H-1 RFEs. So let's get started. Now, if you missed last week's webinar, please subscribe to our YouTube channel. We're going to be having, like I said, all sorts of resources to kind of update that channel, and, you know, with remote work or permanent residence processing. And, you know, let your friends and contacts know that we've got webinars every Wednesday. And if you've got a particular topic you want us to address, email us at info@challalaw.com. So, specialty occupation, that's usually the most critical thing when it comes to H-1Bs. What does that mean? If you remember, an H-1B is deemed a specialty occupation because it takes a minimum of a bachelor's degree or its equivalent for you to be eligible for the H-1B. So it's not only that you have the equivalent of an H-1B, but the job has to normally require an H-1B, and therefore it's deemed a specialty occupation. So how do you meet that criteria? Because this is one of the most common issues that comes up on the RFEs. So you just have to meet, as per the regulations, you just have to meet one of the 4 prongs. That is that a minimum of a bachelor's degree or its equivalent is normally the minimum entry for the position that you're outlining, or that the degree is common in parallel positions among similar organizations. And prong 2 has kind of 2 alternatives to it. You can either show that, or you can show the position is so complex and unique that it can only be performed by an individual with a degree, or that the employer normally requires a degree or its equivalent for its position, or the nature of the degrees are so specialized and complex that the knowledge required to perform the duties usually is associated with a bachelor's degree or higher. Now, you only have to meet one of the four prongs, but I like to meet all of the four prongs when we're discussing specialty occupation. And there's some court cases that really support us in making this affirmation, and we'll be talking a little bit about those court cases as well. So, that the bachelor's degree is normally the minimum requirement for the position. How do you prove that? Well, the evidence usually, well, the service will usually reference the Occupational Outlook Handbook, and I'll talk a little bit about that in a second. And they'll usually point to some language in the Occupational Outlook Handbook that states that it is not always required, and always is not the criteria. It's normally required for the position. And sometimes there's a lot of articles. For example, user interface. And I use that because the OOH was modeled after the government job titles a long time ago. And because, you know, technology is developed, there are positions that weren't even envisioned back in that time. So as a result, the references they're using are kind of dated. They really don't provide or show exactly what typically is normally required for the position. But there's a lot of articles that talk about the growth of various positions and explain, in addition, what those positions do and why the technology and what's required for someone to be able to do that work. So I use user interface because, you know, back in the day, user interface was the mouse, right? It was the mouse. It was very simple stuff. Now user interface, especially with smart appliances, AI, you know, user interface is everything about the customer's experience with that particular technology. And so a lot of times a person that is doing user interface work may not have typical IT background. They may have something in design. They may have a degree in branding. And so the USCIS may have difficulty understanding how that relates to something that's involved with technology. So the way to explain that is through, I submitted a ton of articles that kind of highlight what user interface is about. Second, excuse me, we always use, we go back to the OOH. Now, the Occupational Outlook Handbook, you can Google it, it's online. And you should actually proactively look at that before you file your H-1, because a lot of times there's many positions, you know, it's very fluid, whether you would be classified as one or the other. And so the Occupational Outlook Handbook is the reference that the USCIS looks at. And so determining which job title to use can be helpful in that situation. And it's important to note that the adjudicator's field manual, that's what the USCIS is supposed to use as their guidelines for adjudicating H-1B cases, states that that the OOH should only be used as a reference, that technology is ever evolving, and that shouldn't be the last and final word. You should look to the duties. You should look to the background of the individual. And so that's why the job description is really important. And finally, the ONET. The ONET is what's used when you file a perm application. And the ONET is a little more updated And so, you know, the adjudicator's field manual even references how the ONET may be a better resource than the OOH. Now, in understanding this particular, remember I said it was in two prongs, right? So you've got the first prong, that a degree is common to the industry in parallel positions among similar organizations. So you have to parse through this. I often say that immigration is almost like a mathematical equation, right? A plus B equals C, or A plus B plus C equals D. So D is, what we want it to equal is that it's a normal requirement. And how we prove that is, A, it's common to the industry. So how do you do that? One of the ways you can show it is job postings of similar job titles, but they have to be parallel positions. So the job duties have to be very similar to the job duties that you're doing. It's not just a title, but the job duties. So if you were working as a software architect for, and the end client happens to be a pharmaceutical company, you may want to look to other software architects that are working in the pharmaceutical arena. And lastly, it's similar organizations. So the size of the organization matters. If your petitioner has 50 employees and it's relatively small, you want to look for postings with other organizations that are of the same size. So it's A plus B plus C equals that it's a normal occupation. And you can look at articles and research papers for that as well. So that's prong one of two. That's, I would say, A. So prong two is that the position is so complex or unique that it only can be performed by an individual with a degree. You know, the best way to explain that, and like I said, I keep this in mind prior to filing the H-1B, because I think being proactive is much better than having to deal with the RFE and be reactive. Having said that, even when we're doing that, now because of the impending furloughs and the fact that the USCIS is so backlogged, as soon as you upgrade, you're going to get a standard RFE just so they can buy some time. And to explain that, I talked about it in last week's webinar, but when you pay premium processing, you're paying $1,440. And the USCIS has to adjudicate it within 14 days. 15 days. So in order to do that, in order to buy themselves some time, the exception to that is if they issue an RFE. So a lot of times you're going to get RFEs, even that doesn't mean anything about the merits of your case or what you submitted. It's just so that you can buy some time. But even then, you don't want to take it lightly, because this is your last bite at the apple before there's an adjudication. So the position is so complex, you want to detail the job duties, maybe even relate them to the courses the individual took, with an explanation relating to the complexity of it. Can help with that. And I see there's some questions. I'm going to answer those questions right after we get through this. Prong number 3 is that the employer normally requires a degree or its equivalent for that position. So how do you prove that? You can show if the employer's placed any ads for that particular position. You can also show an organization chart with other software. Let's go back to the example of software architects. Other software architects with the same degree. So you'd have to show who they are. You have to make sure that you prove that they're on the employer's payroll, so either pay stubs or quarterly pay statements, and then either copies of their degree or their LinkedIn pages to show that they do have a degree. Now, the issue is going to be if they're not all in a similar field. They don't have to have the same degree, but they have to have a similar field. So you want to keep that in mind when you're using this particular criteria. And then wait a minute. Okay, and then finally, that the nature of the degrees are so complex. This, if you see this, it's almost similar to prong 2B. So you can say see above, or if you want to expound on it, you can expound on it more. But you only have to meet one of the four. But like I said, we try to meet all four to say it's overwhelming evidence that this is clearly a specialty occupation. Now, other RFEs, you know, this is what I was saying, that that the job duties, the beneficiary's background is equivalent. So sometimes what we'll do in that situation is, if a person has a degree in a specific area that may not be related, but it's tangentially related, but it's he or she has tons of work experience. What we'll do is we'll get an experiential credentials evaluation that takes into consideration their experience to give them a degree that's more related to the particular occupation. So you want to make sure you do that. You want to make sure that it's aligned to the code on the LCA, because a lot of times people will state a position, but their job duties may be a little varied. So it could be a hybrid of another position. So you want to keep that in mind. And finally, entry wage levels. Now, in 2017, there was a memo that was published specifically for computer programmer that said computer programmer can no longer be considered an entry-level position for an H-1B. The USC took that and expounded it and said, you know, no position can be an entry level. What we have done is we've made arguments, you know, like for example, if you have a new doctor, they've got the degree, but the doctor is usually supervised initially. A lawyer who's got a law degree would actually be working under a senior attorney who's reviewing their work until they're trained to get up to speed. Those are all entry-level positions, and they're clearly specialty occupations. But, you know, their wages would be under the entry level. So that's a way in which you can get through that. Let's answer a few questions before we go forward. Okay. Since the USCIS will run out of money in August, does this mean that processing new applications will stop, or there'll be a snail speed trickle? Yes, it will be you hit the nose on the head. I don't know how they could get any slower, but they can't stop. The thing is going to be that they're not going to be able to stop premium processing because they need the money. So, you know, we're hoping there's a lot of support in Congress for increasing their budget, but we'll have to wait and see. But until then, 13,000 employees at a system that's also very slow is really going to impact their processing. Second question. John will be applying for my I-140 this month. How are the expected current USCIS and presidential orders, current or expected, going to affect this? You know, and we went over this before, that the president can only 212F, which gives him the authority to, a very broad authority, mind you, only gives him the authority for entry of individuals, does not give him the ability to dictate people who are already here. So I think that there shouldn't be any issues on that front, especially permanent residents. And as I've stated in the past, I really encourage folks to undertake their permanent residence as soon as they possibly can, because it gives you greater security and greater options. So it is important that folks do that. Another question. then is it not recommended to go with premium processing? I wouldn't say that because the backlog is so high. I think you can time it. Remember, when you file for an extension, you have 240 days in which you're authorized, if you file it timely. That means you file it before the expiration of the current status. You have 240 days in which you're authorized to work in the United States. And the portability of H-1s allows you to work for a new employer as long as it's been received by the USCIS. Now, what you can do is let that process for a little while and then upgrade it later when you deem it's necessary. But if there is no reason, at least until the shortfall with the USCIS is addressed, you got to expect an RFE. If you think you can overcome the RFE, then there's no reason why you shouldn't upgrade. As long as you are ready and you're able to respond successfully to the RFE. So it becomes a strategy issue on how confident you are that you'll be able to respond to the request that's outlined. Our last question before we go on, and I'll continue answering, but I want to make sure that we go forward with the PowerPoint. How will the slowdown affect green card application process? Well, it depends on what type of process, right? So the USCIS, for normal green card processing, you've got to file a perm with the Department of Labor. So the USCIS shortfall will not really impact the first portion of it. The second portion of it is with the USCIS and the I-140. Now, if you're the person that's processing your perm, really should look at I-140 issues at the DOL level. The reason is you want to make sure that there is no issue that comes up on the I-140. And so if that's the case, you can file the I-140 premium and get that approved pretty quickly. But like I said, you want to make sure that your lawyer and your employer are addressing all the I-140 issues before you even start your perm processing. And that way, it's smooth sailing down the road. We make sure we do that. The two main issues are making sure that the beneficiary has all the education and experience prior to joining the employer. There are a few exceptions to that, and the ability to pay issue. So those are the two things, and we've covered that in one of our previous YouTube videos. So take a look at that if you want a deeper dive into I-140 processing. I see there are more questions, but let's go on to the next slide, and then I promise I will answer all your questions. Another issue that comes up is right to control, because you want to make sure that the USCIS wants to make sure that the employer is actually controlling the work of the employee. Now, that issue should only come up for third-party placement. That means if the employee is working at a location other than the petitioning employer. If the employee is working at the employer's work site, then you just cite that it's traditional employment, and the issue of right to control does not matter. But if it's not, you want to show evidence that the employer has the right to control, by showing, their contracts, itineraries, and you need to show it for the duration of the time period that the employee is indeed working at the third-party site. So statements of work orders, sometimes if you can prove that, excuse me, even though this particular, I've got allergies, so even if this particular contract for the work that you're currently doing is running up, that they have an abundance of other work. And so there is the argument of what I call sufficiency of work. Well, I shouldn't use quotations because it's a real thing, but it's sufficiency of work. Sufficiency of work is very different from, so you have to show that the work available is not speculative, but it's anticipated, right? So that's the threshold, that the work is anticipated. So if you're able to show that, hopefully you can get the H-1B validity for the 3 years instead of a shorter period. So I will answer some questions before we get a deep dive into the cases. I think, let me scroll to the top of this question. I'm outside of the country in the UK. I got my H-1B transferred to a new employer. Validity till April 2023. I'm currently outside the United States. I can't go to the stamping with a new employer as it's currently closed. I have a previous H-1B stamped only. What are my options? Also, can I work for a client with a new employer? Well, okay, so they want to know whether they've changed employers. And so they said that the consulates are closed, so they can't get their visa stamped. But they have a valid visa, H-1B visa, with the previous employer until 2020, September. And lastly, they want to know if they can work for the new employer outside the United States because they have an approved I-797. So let's address the visa issue. If you look on the Department of State website, a visa is valid unless the Department of State withdraws it or it's revoked. Okay? So a visa, your H-1, just like for an F-1 visa, even if you change academic institutions, that F-1 visa is still valid. The same thing with the H-1B visa. The visa is valid even if you change employers. You don't need to get a new visa unless it's revoked or the Department of State withdraws it. So you can travel back to the United States with your old visa before it expires in September 2020. But remember, in the midst of closed embassies and everything else, there's also travel bans. So currently there is a ban from people entering the United States from certain countries. So I believe the UK is one of them. So until the COVID ban is lifted for travel from there, that would be a bigger issue. But you can, from an immigration perspective, return back to the United States on your old visa before it expires in September 2020. Your second question was, can you work for your employer on your new approved I-797? Absolutely. You can work overseas until the travel ban issues are addressed. So you can work remotely. I hope that answers your question. And then I think we had another question on the Q&A. Let's see. I-140 premium is not available for multinational managers or executives. Correct. It is only available for extraordinary ability, really, under the EB1 category. So unfortunately, it's got to go through the regular processing. This is an anonymous question by an anonymous attendee. Does 6 years of the H-1B have to be continuous, or can someone be on an H-1B for 3 years, change to F-1 for 1 year, and then be back on the H-1B for another 3 years? So the individual wants to know that whether the H-1B, does that clock keep ticking even if you change statuses to another non-immigrant category? Well, there are two rules that are pertinent for this. Number one, the rule is your 6 years on an H-1B count only for the years you've spent in the United States on that status. So there are two portions to that. One, the period you're outside the United States, even if you're on an H-1B, doesn't count against the 6-year maximum. Number two, the time that you're on another non-immigrant category doesn't count against the 6 years. Now, whether you are not subject to the cap, you're cap exempt because you've been previously issued an H-1B, depends on whether you've held the H-1B status within the past 6 years. So if you've held it within the past 6 years and you're now on another non-immigrant status, then you can change status back to the H-1B and be considered exempt from the H-1B cap. So I hope that answers those questions. Let's go to the live. I know there's another question on chat, but I'm going to go back to that in just a second. I want to get through these court cases because that may answer some of the questions you all have. So recent H-1B decisions have really impacted adjudications. And it's important for everyone to use that when they're defending the RFE, not only proactively. Usually with these particular court cases, it's more of their tools or weapons or whatever you want to call it for responding to the request for evidence. So specialty occupation. The beneficiary had a mechanical degree, and the USCIS argued that a general degree in engineering or another subspecialty is not closely related to the specific field. The court disagreed and said the U.S. interpretation requiring a degree in a singular subspecialty was utilized ad hoc and not accordance with the regulation. And we've also further explained that engineering gives you the ability to analyze business problems and come up with an algorithm or a solution to address those problems in a methodical, quantitative, qualitative manner. And so the reason why engineering can't be in a specific engineering degree is if you're doing IT in the aeronautical industry, maybe you've got an aeronautical engineering degree, but you've got 5 years of work experience in software development, software solutions. Then clearly you've got the background and education to, and the same thing that would apply for other engineering subspecialties. So the mere fact that you've got an engineering degree and the OH says engineering is one of them, you don't have to identify that it's a subspecialty. And I'm so glad that the court stated that it was ad hoc and it doesn't have to be in a subspecialty. So the DOL in arguing the employee-employee relationship has, stated, the idea of employee control, there's like a 10-pronged test. So the policy memos, they said, cannot be used to target IT consulting companies. And the DOL, as long as you're able to show that you can otherwise control the work, you can't just assume that just because somebody works with an IT consulting company that, that they can't control the work. So the USCIS pointed to the itinerary and control memo. The judge determined that the requirements were applied without rulemaking and can't be enforced. Anti-benching allows the employer to keep the employee during non-productive periods as long as they're paid. And short approvals, they can't give short approvals without a reason. And requiring contracts or other corroborated evidence of dates and locations of work for full 3 years, it is in fact a total contradiction of the plaintiff's business model, providing temporary IT services to U.S. businesses. So what the USCIS was doing was they were using the contracts, and they would say, okay, if your contract is only for 3 months, we're only going to give you a 3-month approval, without taking into consideration that that's the nature of IT consulting, and that's the nature of the business, that you only have short approvals, short contracts, which can be renewed. And it's usually the language within either the master service agreement that will say, the work orders will only be 3 months, but they will be renewed shortly thereafter. And the reason why companies will do that is, their needs may change. They want to make sure that service levels are being met. And so we have in the past outlined that, again, it is as long as we can show that there is anticipated work and that we are not outlining speculative work, that it should be, it should be approved for the full 3 years. But this court case helps us in identifying that, hey, you can't use that. And they did enforce that. They did it through memo without rulemaking. And it was really a big change, because if the regulations say you can't have anticipated work, you can't have speculative work, but if you can show anticipated work, and we've got other evidence to show that, more likely than not, that the employee will be paid during the full 3 years, the USCIS can't intercede and say, hey, that's not enough. And the DOL, as I said, the Occupational Outlook Handbook often uses the word common. Your degree is common, for the industry. And the agency started saying, well, common doesn't mean, we'd even reference the Webster's Dictionary. This is what the Webster's Dictionary says is for the word common. But there were several court cases where they said common actually means normally. And the agency can't substitute the word always for normally. So those are, like I said, really helpful if the OOH, for example, like in the sample cited, states that it is common for the individual to have a degree, and highlight that these court cases affirm that that is common within the industry. And I wanted to take a little deeper dive into the judges, the language that the judges had. It was great. But let me answer a few questions, because I see that we've got several questions. I am laid off on an H-1B, valid up till 8/21, I-94 until May of 2021, and I applied for a B1. Can I come back on my H-1B stamped visa again once I leave the country? As long as you got a new 797 with a change of employer that shows that you've got a current H-1B that is valid, absolutely. You can do that, even if you decide to depart the country after filing for a B1 change of status. Family-based green card processing is shut down at the consulates outside the United States, and there's talk of a big spillover to employment visas next year. Any insights are the same? Not sure if today's discussion is appropriate to discuss the above. It's always appropriate to discuss any question you want. So for the first question, the individual asked that they have a valid H-1B visa stamped, but they currently are laid off. So if they depart the United States, again, look at the Department of State website. It says a visa is valid when issued unless it is revoked or withdrawn, which means you can use your visa with your previous employer as long as you're able to present at the port of entry a current I-797 that shows you've got current employment in the US. To enter without doing that, especially when, even though you have a valid visa, number one, you'd be stopped at the port of entry. And number two, it would be making a misrepresentation. So you want to make sure that you've got an I-797, an approval notice with a new employer to do that. Second question is, because family processing somewhat is shut down, there's some exceptions to that. And family processing is not being shut down. For the most part, it is primarily, it depends on the relationship, but they're asking, since consulates are not processing that, there's talk of a big spillover to employment visas next year. Any insight on the same? I don't think so. And I think this may be addressed very shortly. So I don't think that it would be a spillover or an issue you will see on the employment side. And remember, we've got an election this November. So depending on who wins, there may be a total overhaul. And I know one thing that has gotten bipartisan support is reducing the backlog for employment-based visas. So, you know, we got to stay tuned to see what exactly how that will play out. Did you feel that this court case win is a short-lived and the USCIS will come down the line with more detailed rules? They may, but it may seem some challenges because these are, the USCIS can clarify rules, can change things that are not under the purview of Congress. But remember, if the particular notion is where Congress has issued regulations for, only Congress can undo that. So it would be outside the agency's ability or authority to be able to then, you know, re-legislate something that Congress has intended. And that's actually a great question because I'm going to go through that in just a second as soon as we get through some of these questions. I'm looking to start my permanent residency with my employer, but my passport expires. Can I start the process without a passport or change passports later on after the process is started? Well, if you're going through the perm process, then you can go ahead and get that started without your passport being valid, but I'd go ahead and get the process rolling with trying to get your passport renewed. Can we transfer H-1B with another employer after the I-94 expiration date while the current H-1 extension is pending? If yes, what are the risks doing an H-1B transfer after the I-94 expiration? Well, you can, because you're in a stay authorized by the Attorney General. You're in an authorized stay. And you are working with authorization because of 240-day rule. So when you file for change of employer, you'd file with a receipt notice and the receipt notice of your extension to prove that you're in an authorized status, and pay stubs to show that you are being paid during this period. Sometimes the only issue is that, and we've been able to overcome that, is if your employer filed your extension and made representations that he or she cannot uphold, like, with that you're working on a particular project or so forth. But even then, I would state that your change of employer should be approved. And if it's a strong enough case, what I would do is just go ahead and file a premium. That's when I would file premium. Again, these are strategies. You don't want to do it for everyone. But if your new employer has all the documentations in place, file a premium processing. And if they come back and say, well, wait a minute, you've got to wait till your previous extension is approved, you can say you're a status authorized. So there's nothing really in the regulations that state that you have to wait for that to be approved in order to leverage that particular ability to change employers. Okay. Is the sufficiency of work, this is another question, is the sufficiency of work related purely dependent on the client contract dates, or is it dependent on other criteria? True. How to ensure the 3-year extension when working at a client site when the contracts are not awarded for 3 years? Exactly. So that's a good question. So what you would want to do is you just got to show that the employer, and because of USCIS, because of that new court case, you just want to show that the employer, you know, how long has he been in business? How many employees does he have? You know, if the employer, I hope he has been paying the employees the proffered wage for the years that were, if they can show evidence of that, all that will prove that the employer has sufficiency of work. Other contracts, tax returns. There is something called the, where you can take the totality of the evidence. That's the standard. So you want to submit different types of evidence and say, from the totality of the evidence, using the preponderance standard, which that's the standard for USCIS adjudications. And preponderance means more likely than not. It doesn't mean that you have to prove that there's no question or no issue. It just means that it's more likely than not. So if you're able to show that standard, you're in great shape. So that should be what you do going forward. So here it was a case where it was a hotel management, and they said that in you know, the hotel, the H-1B had been approved twice, and they said that the USCIS stated that it wasn't a specialty occupation. And when I was reading the court case, they actually talk about, they looked at the degree, the experience, and how there are programs, degree programs now in hotel management. So there's no reason why hotel management would not or should not be deemed a specialty occupation. So I wanted to highlight some key points, and this is tailor-made software versus Ken Cuccinelli. And Ken Cuccinelli was the Attorney General of Virginia many years ago, and I was his immigration special counsel. So anytime I see his name, I think about my years with him and working as his immigration resource. And clearly, he didn't pay much attention when I was counseling him those days. But the judge, the U.S. District Judge, said that the USCIS was wrong to declare that computer systems analysts that have a liberal arts degree and gained experience elsewhere cannot be a specialty occupation. And they go back to talking about the Occupational Outlook Handbook. And they said that bachelor's degree in computer information systems is common, although not always a requirement. And he further states that, again, the regulatory criterion, that's the criteria that's outlined by the regulations. So that's what Congress has written, right? So an agency can't override what Congress does. It can clarify, it can outline new procedures and things like that, but it can't rewrite what has been legislated. So he said, again, the regulatory criterion is not whether such a degree is always required or whether some employers do not require it, as the USCIS claimed. So the criteria is common. Another case that we had talked about a little bit, but I wanted to kind of go into the issue. This was also issued on March 1st, 2020, and it's InfoLabs versus the USCIS. And the USCIS denied an employer's H-1B petition for a computer systems analyst on the grounds that InfoLabs failed to establish that the position qualified for specialty occupation. And so the judge stated that the handbook statement that a bachelor's degree in computer or information science is common or is not always, is not, you know, that it's common and although not always a requirement, supports rather than disproves that, I'm sorry, I'm getting a question here, that the proposition that a specialty occupation or its equivalent is normally, which is what the standard is required for the degree. I mean, required as a minimum requirement. The fact that such a degree is not always required, or that some firms hire analysts with a general business or liberal arts degrees, does not suggest that special degree is not normally required. And again, they cited to 3Q Digital Inc. versus USCIS, and they said, the regulation does not say that a degree must always be required, yet the agency appears to have substituted the word always for normally. This is a misinterpretation and a misapplication of the law. So those are the quotes that should be used in your RFE. And then, of course, we talked about this a little bit, about the hospitality management degree, India House versus Kevin McAleenan. So here, they said the very fact that the bachelor's degree curriculum there's a bachelor's degree curriculum dedicated to hospitality management focused on food service is indicative that it's a specialty occupation. And so it should be approved. So these are, and the reason why I wanted to share the court cases is so you could see what the dicta was, you know, in doing this. And I'm only sharing what our records have been. And for the two H-1Bs, actually just the two that we had denied, they were approved on a refile. Same exact petition, they were approved on a refile. And the two on an RFE we're dealing with, that we got denied, we're dealing with a company that insisted on trying to classify itself as a H-1B exempt employer. So we filed for them twice. And we didn't think that that would be the best fit. But I show you this because proactive, you know, work and making sure that you are trying to address this up front is really critical in making sure that your H-1B is successful. It is no longer a cookie cutter. So, you know, you can't process H-1Bs the way we did in the past with generic job descriptions that are pulled off the DOL's website. They've got to be very specific. And you've got to keep all the issues in mind proactively when you're filing, and then, you know, the success rate will be better. So the Department of State announced that they would open up their consulates and start visa processing. They haven't stated when they do that. I think it depends on country conditions. And even if they do that, you have the whole issue of, you know, the travel bans and not being able to move forward. So the interesting thing is there is a lawsuit against the President's Proclamation. We've been talking about how there would be a lawsuit. And I think I'm sorry. I think I touched on this a little bit when I talked about what the president's authority is and how this was slightly different. If you remember when I talked a couple of weeks ago, I had addressed the presidential authority when we were anticipating what would come down the pipeline. And I said 212F only allows the president to override particular provisions of the INA. Remember, he can only restrict entry, and that's what he's done. So he's got that portion covered. But previously, whenever there has been an executive order barring entry, it's typically been for national security. So the courts have said, they even said it in Trump versus Hawaii, we don't expect the executive branch of the government to, in a courtroom, explain its reasons for national security because the confidential nature of it, because, you know, national security they don't expect the executive branch to come out and say, well, we're worried about this, and lay out things that are highly secure and highly confidential. And also they stated that there was a lot of discussion about what is exclusively in that the president can do under as the executive branch, and what is primarily in the authority of Congress. So the president can't, in other words, override what Congress has put forth. So here, one of the things that they're alleging in the lawsuit is the proclamation overrides the detailed and statutory, and subverts Congress's legislative intent, regulating employment of foreign nationals and providing the needs of the United States employers. And I haven't read the entire filing to see what they said, but I hope that they've stated that a lot of these individuals, number one, have an approved petition by the USCIS. Department of State only has the authority to deny an H-1B if there's fraud or misrepresentation. They cannot re-adjudicate what the USCIS has already approved. So if they have an approved petition by the United States based on the regulations set forth by Congress, and your argument is not national security, it's the economy, and these individuals are still getting paid by their U.S. employer, but we're not getting the benefit of the payroll taxes and everything else, I think that they do have somewhat of an argument to be made that what the president is doing is actually circumventing what Congress specifically had outlined. So they're stepping on, we have a separation of powers in the United States, so this way the president is stepping on an area that's exclusively for the legislative branch. The other issue is he's not alleging national security. He's alleging economy. So that's not something that is highly confidential or secretive, or they cannot put forth and explain and give their reasoning behind. So it'll be really interesting to see how this goes through. And remember what I said previously, that the way this works is when you file in district court, that, as long as even if you file, like the F1 lawsuit was filed in Massachusetts, federal district court in Massachusetts. So it doesn't matter what district court you filed in, the district court judge can issue a statewide injunction enjoining the president from, moving forward with the ban. Now in Trump versus Hawaii, they did that. The federal district court did that. But when the Supreme Court granted cert that it would hear the case, they stayed the injunction. And they said, we're going to let the ban continue while this case works its way up the court. So we'll have to see what they will do in this regard. But I was hoping for a legal challenge, and we have gotten it. So that is good news. So those are the two main updates we had, aside from the great news we had for F1 students. If you have not signed up to get our immigration updates that we send out, please sign up by emailing us at info@challalaw.com. Remember, we have our webinar every Wednesday at 12 p.m. And so I hope you will join us on the next webinar. I'd love to hear from you if there's any specific topics you want us to cover. I'm doing this to benefit you. So you have to let me know if there's a topic we haven't covered, or is there something you'd like us to cover for our next webinar. Again, email us at challalaw.com. And remember that the previous webinars are on our YouTube channel. Subscribe to that channel. Follow us on social media. We use the different platforms for different types of messaging. and share it with your friends. Let's make sure that we get out as much information as possible to help the greater public with their immigration questions. You know, it's a very troubling time, and people are stressed. So we're hoping that, you know, our webinars and our resources, we can reduce the stress by maybe just a little bit. So by sharing it with your friends, we can, you know, impact a larger group of communities. This Sunday, I'm doing a webinar for the North Carolina Telugu Association. So, you know, we're also trying to target various communities when they wanted a smaller platform to be able to do that. And email me. You know, I always look forward to hearing from you. Comment on our YouTube. Tell me how we can do things better. I know that initially when we first started doing YouTube, the lighting was off and it wasn't very clear. So thanks to your input, we've been able to address that. And I think there is one other last question. Can people waiting in queue due to country quota limits with approved I-140 for years be put in any unfavorable situation because of new immigration changes? Or would this be only for new applicants? What are your thoughts on this? No, I think if you've got an approved I-140 and you're waiting per country limits, I wouldn't travel right now until this is resolved. But I think that you are in good shape and you're safe. So you should not have any problems. I think there's one last question. How will the agency insolvency affect immigration processing? And so, yeah, I mean, it's going to slow down processing. There is no way out of that. But I think that, you know, it will get better before it gets worse. So, oops. I think we're okay on that front. And then somebody asked whether they can take their I-797 approval to get their driver's license. Absolutely. The DMV should issue you a driver's license based on your latest approval and for the full term of where the approval notice is, how it's issued. So should not have a problem with that. And I want to thank you all for tuning in today. And I hope to, you know, to see you next Wednesday. Like I said, connect with me. I'm trying to get to as many of the info at Challa Law as I possibly can, because I want to respond to you myself, because I told you I want to connect with you. So I don't want to use someone else to connect with you. I want to connect with you. But I am getting to them. And have a great week and stay safe. Feel good about the lawsuit, the fact that they had to rescind the F1. I told you that all this negative stuff is only temporary. The light is at the other side of this tunnel, I promise. Take care. Again, this is Lakshmi Challa, and I'll see you next week. Bye-bye. Yeah, I just wanted to clarify the question on the DMV. The approval notice for your extension, on the bottom of it, that's the I-94 card. So you do have a new I-94. So the I-797 that's issued for an approval notice in the United States, the bottom of it is your I-94 card. So that's what you will use to renew your driver's license or get a new driver's license. Either way, it works. So be safe, take care, and I look forward to seeing you guys next week.